What if everything most people believe about a billionaire, about power, about influence, and about how the system really works turns out to be wrong, not slowly, not quietly, but all at once and in public? Because here's a fact that cuts through years of branding and myth-making. A former president of the United States was just told by a judge that his legal arguments were frivolous, baseless, and not worthy of the court's time. And that same ruling opened the door for his assets to be seized, not negotiated over, not delayed, not symbolically threatened, but taken. And when a court reaches that stage, it signals something unmistakable. The system believes the judgment is real, the debt is real, and the excuses are over. This is not gossip or partisan framing or a talking point meant to inflame emotions. This is about Donald Trump, the business empire built around his name, and a legal decision so blunt in tone that even seasoned legal analysts noted how rare it was, because courts usually speak cautiously, yet here the language was firm, decisive, and final. Properties that defined skylines and reinforced an image of permanence were suddenly exposed to enforcement because the judge rejected last-minute attempts to stop a process that had already been lawfully set in motion. So the real question is not whether this came out of nowhere, but how it reached a point where the court felt no obligation to soften the blow, why the arguments were dismissed so completely, and what it means when both the legal system and the financial system reach the same conclusion at the same time. Because when that alignment happens, power stops being performative and starts being measured. And to understand why this moment matters, you have to start with what many people overlook. This was not a surprise case. It was not rushed. It was not political ambush litigation. It followed a full civil fraud trial in which evidence was presented, witnesses testified under oath, documents were examined, defenses were raised and rejected, and the court ultimately ruled that Trump had engaged in persistent and repeated fraud over many years. That ruling already existed before any emergency motions were filed, so when the judge later denied Trump's attempts to halt enforcement, she was not reconsidering guilt or reopening debate. She was enforcing a judgment that had already passed through the system exactly as civil law requires. Trump's legal team framed the enforcement as sudden and unfair, but the judge made clear that nothing about it was unexpected. Losing a civil fraud case involving hundreds of millions of dollars carries consequences, and calling those consequences unconstitutional or irreparably harmful does not change how the law works once a final judgment is entered, because in civil cases, once that line is crossed, the law moves from argument to execution, from debate to enforcement, and courts do not pause indefinitely simply because a defendant disagrees with the outcome. And this is where the tone of the ruling became important, because the judge was no longer entertaining hypothetical concerns. She emphasized that Trump had multiple opportunities to avoid this moment. He could have complied with the law in the first place. He could have settled earlier. He could have followed standard post-judgment procedures, but instead he chose delay, denial, and escalation. And the court recognized those tactics for what they were, because final judgment carries final authority. And when defendants refuse to accept that shift, the system does not compromise. It proceeds, which is why asset seizure was not extreme. It was inevitable under the law. And this inevitability became even clearer once the case moved from the courtroom into the financial arena, because after losing the fraud case, Trump had a standard legal option available to him if he wanted to pause enforcement while appealing, post a bond. That bond exists for a simple reason: to guarantee that the money awarded by the court will still exist if the appeal fails. Courts do not rely on promises, especially after a fraud ruling. They rely on security, and without a bond, there is no automatic pause, no stay of enforcement. And Trump's legal team argued that the bond amount was unfair, excessive, even impossible. But the judge was unmoved because the requirement is not discretionary or tailored to status. It applies to everyone If the judgment is large, the bond is large. That is not punishment, it is proportionality. And the court made clear that an appeal is not a free delay pass. You are allowed to challenge a ruling, but you are not entitled to freeze its consequences unless you meet the legal standard. And what transformed this from legal trouble into a financial emergency was what happened next. Trump's lawyers admitted in court filings that they had contacted dozens of bond companies and failed to secure one willing to take the risk, and that admission mattered more than any argument they made, because it was not the court rejecting Trump, it was the market, private financial institutions whose business is assessing risk independently concluded that backing Trump's bond was too dangerous. And courts do not override that reality, they respect it. Because when the market refuses to underwrite your claims after a fraud judgment, the court does not rescue you, it steps aside and allows enforcement to proceed. And at that moment, the issue stopped being about law and became about credibility. Because credibility is the currency that allows financial systems to function. And once it collapses, the system does not slow down, it accelerates. And this collapse became even more apparent when Trump argued that his properties were enormously valuable and that seizing them would cause irreparable harm, because the irony was impossible to ignore. He had been found liable for fraud precisely because he overstated asset values to banks and insurers for years, and now he was asking similar institutions to trust those same valuations enough to back a massive bond, and they refused, not one or two, but dozens. And the judge did not view this as coincidence or bias. She viewed it as confirmation. If Trump's properties were truly worth what he had claimed for decades, securing a bond would have been routine. The refusal was not political. It was financial reality asserting itself. And courts understand how markets work. When every serious financial actor independently reaches the same conclusion, judges pay attention. So the court concluded that Trump's inability to secure a bond was not proof the system was rigged against him. It was proof that his credibility had eroded to the point where no institution was willing to stake its reputation on his claims. And once credibility disappears, courts stop extending patience. Enforcement becomes not aggressive, but logical, because this was not just a legal loss. It was the moment when numbers stopped performing and started reflecting reality. And this framing also dismantled Trump's constitutional argument, one of his most dramatic claims, that enforcing the judgment before his appeal concluded violated his right to due process, because due process does not mean endless delay. It means notice, a fair hearing, and an opportunity to defend yourself, all of which Trump received. In fact, the judge emphasized he received more process than most defendants ever do, and the court explained that New York's bond requirement exists to protect due process, not undermine it. Without it, defendants could drag cases out for years while quietly moving assets beyond reach, leaving victims with nothing even if they ultimately win. And the judge noted that this rule has been upheld repeatedly and applies to every defendant regardless of wealth or fame. Trump was not singled out. He was treated exactly like anyone else who lost a massive civil fraud case, and the Constitution does not guarantee a consequence-free appeal. Enforcement during appeal is normal when a bond is not posted. Calling that unconstitutional was not just incorrect, it revealed a fundamental misunderstanding of civil law, and once the judge framed it that way, the argument lost all force, because the system was not denying Trump his rights, it was preventing him from abusing them, and that distinction mattered far more than rhetoric. Just as the political persecution argument collapsed under scrutiny, because Trump repeatedly claimed the case was a political hit job designed to destroy him. But courts do not deal in slogans or narratives, they deal in evidence. And the judge laid out a simple reality. The case was brought by Letitia James, yes, but it was supported by years of investigation, documentation, sworn testimony, and expert analysis. Trump had counsel, he cross-examined witnesses, he presented defenses, and he lost. Disagreement with a verdict does not transform it into persecution. And accusing the judiciary of corruption without proof is not a legal argument. It is an attack on the legitimacy of the justice system itself. And the judge's tone made clear she found this line of argument increasingly offensive. Because if every losing defendant could cry politics and halt enforcement, the law would cease to function. And this is where Trump's strategy backfired. Instead of persuading the court, it convinced the judge he was acting in bad faith, attempting to weaponize public outrage to escape accountability. And once a judge reaches that conclusion, tolerance evaporates because courts draw a hard line when defendants ask for special treatment. And Trump's arguments taken together amounted to exactly that, a request for different rules because of who he is and the power he once held. But the judge made it unmistakably clear that the law does not bend for status. Once Trump stood in a civil courtroom as a defendant, he stood there like anyone else who had lost a fraud case owing hundreds of millions of dollars. New York's enforcement rules are routine, applied daily to defendants with far less power, and allowing exceptions for influential figures would undermine public trust. Judges understand their rulings, send messages beyond individual cases, and here the message was clear: the rule of law only survives if it applies equally. And Trump's status ultimately worked against him because the court refused to create a carve-out that would invite every wealthy defendant to demand the same. And by the time the ruling was issued, the judge was not just evaluating arguments. She was evaluating patterns, repeated emergency motions, recycling rejected claims, escalating rhetoric without new evidence, tactics designed to slow the clock rather than resolve genuine disputes. And courts are not obligated to indulge delay after a final judgment. Appeals are a right, but abusing procedure is not. And when judges conclude litigation is no longer in good faith, the system stops negotiating and starts enforcing, which is exactly what happened. Patience gave way to action. And the final reason this moment matters goes beyond Trump himself, because the ruling reinforced a boundary that had been tested for years, the assumption that power, publicity, and pressure can bend institutions until consequences disappear. The judge's language mattered because it was deliberate, direct, and clarifying. The courtroom is not a stage. Legal procedures are not performance tools, and losing carries obligations. This ruling stripped away the illusion that wealth or influence creates immunity. It reassured the public that fraud still has consequences, and it demonstrated that courts will not blink simply because a defendant is famous or polarizing. Love or hate for Trump is irrelevant to the law, because the system either applies equally or it fails. And by allowing asset seizure to proceed, the judge chose principle over pressure, setting a precedent that will echo far beyond this case, shaping how powerful defendants are treated in the years ahead. And this is where the broader implications become impossible to ignore, because once the court draws a line this clearly, it doesn't just affect one defendant, it resets expectations across the entire system. Wealthy individuals, corporate executives, and powerful organizations all pay attention when enforcement reaches this level, because it signals that delay tactics, branding, and public pressure no longer carry the weight they once did. For decades, the assumption at the top tiers of wealth has been that consequences are negotiable, that time itself can be weaponized, that appeals can stretch on long enough for circumstances to change, attention to fade, or leverage to return. But this ruling directly challenges that playbook. It shows that courts are increasingly willing to move swiftly once they determine a judgment is final and delay is intentional. And that shift matters because civil fraud cases don't rely on prison sentences to enforce accountability. They rely on financial reality, and financial reality only works if enforcement is credible. Without it, judgments are symbolic, and symbolism is useless to victims and corrosive to trust. The judge understood this, and her ruling reflected an awareness that allowing continued stalling would effectively reward the very behavior the court had already condemned: overstating assets, manipulating valuations, and exploiting institutional patience, which is why the language was so firm. It wasn't personal, it was corrective. It was the court asserting that process is not infinite and that legal rights come with reciprocal obligations. This also explains why claims of irreparable harm failed so completely, because courts do not accept harm arguments that are self-created. When a defendant refuses to follow standard procedures and then claims enforcement is unfair, judges see through that contradiction. The harm was not caused by the court, it was caused by the defendant's own decisions. And that framing appeared repeatedly throughout the ruling. The damage described was not external, it was self-inflicted, and that distinction strips away sympathy. Courts are designed to prevent injustice, not to shield parties from the foreseeable consequences of their own strategy. And this is where the ruling becomes almost instructional. It sends a message to future litigants about how not to behave after losing a major civil case. Do not recycle rejected arguments. Do not escalate rhetoric without evidence. Do not substitute publicity for compliance, because those tactics do not preserve rights. They erode credibility, and credibility is the one asset no court can supply for you. Once it's gone, everything else moves faster. Enforcement accelerates, patience disappears, and discretion narrows. This is also why legal analysts focus so heavily on the tone of the decision, not because judges are emotional, but because tone reflects confidence. And this ruling was written by a court that was confident it was on solid ground. Legally, procedurally, and institutionally, there was no hedging language, no suggestion of uncertainty, no invitation for further delay. It was the voice of a system saying the process has run its course, and now the outcome must be honored. And for a figure who built an entire public identity around winning, around leverage, around projecting control, that moment is uniquely destabilizing, because courts do not negotiate narratives, they enforce outcomes. And when enforcement begins, perception stops mattering, valuations stop being aspirational, and assets become numbers on a ledger subject to lawful seizure. This is why so many observers describe the moment as a turning point rather than just another loss. It marks the transition from influence to consequence, from argument to arithmetic, and from strategy to reality, and that transition doesn't reverse easily. Once assets are in motion, once enforcement machinery starts, momentum favors the system, not the defendant, which is why this ruling will likely be studied long after the headlines fade, not because of who it involved, but because of what it demonstrated, that even prolonged resistance eventually encounters a limit, and when that limit is reached, the response is not dramatic, it is procedural, methodical, and irreversible, and that may be the most important lesson embedded in the decision. Power can slow accountability, but it cannot eliminate it. Delay can buy time, but it cannot change outcomes already decided by law. And when courts choose to act decisively, they remind everyone watching that the system does not operate on loyalty, fear, or spectacle. It operates on compliance. And compliance is non-negotiable once judgment is final.